to their homes in Oregon, and they're not here, which is a detriment to them. They had as much a right to be here as she did.
All right, today's case is a bit of a wild one. We got a self-proclaimed sovereign citizen who just refuses to stop talking and apparently believes the law doesn't apply to her. Throughout the hearing, she constantly talks over the judge and tries to lecture the officers like that's going to help her case. Spoiler, it doesn't. The real highlight here is the judge. He's all business and doesn't tolerate the nonsense for a second. By the end, he hands down a harsh sentence that clearly catches her off guard. Let's jump in and watch this courtroom showdown unfold. And as you're watching, drop your thoughts in the comments. How do you think this was going to end for her?
Yes.
This is the time set for sentencing. Good.
Excuse me, how you doing?
No, I'm talking now.
Okay.
Listen to me. Is your true name and your complete name Shayna Marie Blackshire?
The court lacked jurisdiction over the subject matter.
What is your date of birth?
The court lacked jurisdiction over the subject matter.
The court will accept the court, based upon a verdict by the guilty in this case.
The court lacked jurisdiction over personal addiction.
As a result of a jury trial, the court finds the defendant is guilty in CR 22209. Count 1, unlawful flight from a law enforcement vehicle, a Class 5 felony. This is in violation of ARS 28624C,
Y'all cannot force me to get sentenced.
Yes, I can. ARS 28622, ARS 28622.01, A1, 28624C, 283001, 283304, 283305, 283315, 13701, 702, and 801. The date of the offense was on or about February 5th, 2022. The offense is non-dangerous, and I'm finding it non-repetitive for reasons I'll state on the record. Count three, that she is guilty of count 3, criminal damage, a Class 1 misdemeanor. It's in violation of ARS 13-1602A1, 13-1601, 13-707, 13-802. And she's also guilty of count 4, burglary in the second degree. This is a Class 3 felony in violation of ARS 13-1507A, 13-1501, 701, and 702, and 13-801. The date of the offense was on or about February 5th, 2022. Judgment of the court that she's guilty of count 5, resisting arrest, a Class 6 felony in violation of ARS 13-2508, A1, 13-701, 702, and 13-801. The date of the offense was on or about February 5, 2020.
Excuse me, advisor. Why are they allowed to do such things?
2022. The offenses are non-dangerous and non-repetitive. The reason I'm finding them is the microphone off, Louis. By the way, turn it off.
Excuse me, that's illegal. Y'all can't do that.
No, that's on now. Turn it off.
Yes, it is, Justice.
This is exactly what happens when someone who thinks the world revolves around them finally gets hit with a hard dose of reality. This sovereign citizen clearly sees herself as the victim, no question about it. You can just feel the entitlement coming off her. From the moment she walks into court, she's shouting over the judge like she owns the place. No normal person does that, especially when they're staring down serious prison time. And let's be honest, this mindset didn't just show up overnight. Nobody randomly decides one day, you know what? I reject all laws and social norms. Nah, this took years to build. It's a whole lifestyle. Now, I'm not trying to psychoanalyze from a distance, but there's definitely a deeper story behind this kind of behavior. You tell me, does this not scream unresolved issues and a total lack of accountability? I'm curious to hear what you all think. Drop your theories in the comments. I've got my suspicions, but I want to know if we're all seeing the same thing.
So, the offenses are non-dangerous. I'm finding them I'm finding, you're your own lawyer. He's not your lawyer. He's nothing can do it. I'm finding that they're non-repetitive because I believe that these cases, all of the charges in this case and in CR 2022-208, which is the prior case for which the defendant was convicted, these cases all of those charges could have been brought together and tried together, but they weren't. I'm not criticizing the decision. It is what it is. It happened for independent reasons, but I'm finding that they are not repetitive. All right. So,
I don't want to participate in this. Y'all have to let me go.
Mr. Wagner, do you want to be heard on behalf of the state?
I do, Your
Get me
Honor.
out of here. I refuse to proceed.
And if the victims wish to be heard, we have victims here in the courtroom, a victim, I think, I'm not sure.
No, Your Honor, she's
No, they're not.
outlasted the victims.
So I'll ask the victim. Do you wish to be heard?
The victims have had to return back to their homes in Oregon, and they're not here, which is a detriment to them. They had as much a right to be here as she did for sentencing, but she is her own attorney, and she's drugged us out long enough that the victims aren't here to give a statement today.
Right, so y'all can't do that. Y'all cannot force me. Y'all can't sentence me like this.
Ms. Blackshire, I believe that these are repetitive and that she should be subject to the Category 2 repetitive offender statutes.
Talking about the fall.
She committed these crimes. She was taken into custody for the first crimes, the 208, Your Honor.
Form for the U.S. court system.
She was taken into custody for 208. She made bond and was released on bond, and then she committed these separate offenses
I'm gonna just,
while on felony pretrial release.
I just want to make clear, to save your words, I do intend to impose the enhancement of 2 years for the crimes being committed while on release. So I just want to.
All right, thank
So if there
you,
was
Your
any
Honor.
confusion about that, I wanted to straighten it out. I apologize for interrupting you, but I thought it was something to clarify up front.
This is illegal.
I believe that it's more than warranted. She was sentenced. Those were separate cases. She was released from those cases, and she committed the new cases. Not only did she commit these crimes separately from the other crimes, these crimes significantly, especially the burglary, I believe substantially affected the victim. The victim, the owner of the property at Morningstar Ranch. Yes, she was burglarized before. No real property was taken from there. As you heard, you sat through both trials. But in this case, in this burglary here, count...
Let me out of here. I don't have to proceed with this. Move. I don't have to.
Count 4, Your Honor.
Let me out now.
The defendant confronted the victim at her home and has substantially affected the way the victim feels about her safety and security at the home, which I think is very important, Your Honor, to acknowledge
Hold on,
that.
I'm sorry. I'm getting.
Are you going to allow this?
What's that?
Are you going to allow
No, I'm
this?
talking to you. Why are you taking her up? You're not. Okay.
Because I don't want to be in here.
Staying in.
I'm requested to leave.
Oh, you're bringing the chair in. Okay, that's fine. I apologize, Mr.
No,
That's fine, Your Honor.
I was getting signals from the defense.
That's fine. I also would point out to the court that the unlawful flight from law enforcement.
All right, stand by. Apparently they're gonna restrain her and bring her back in. Thank you. All right. All right. Defendant is back. You may continue, Mr. Wagner.
Thank you, Your Honor. I would also point out to the court that count 1, the unlawful flight from law enforcement, and count 5, the resisting arrest counts, are not in any way connected with the prior the 208 case. They're separate victims there. These are definitely separate incidents. The state would argue that as well for count 4, the burglary, Your Honor.
No, I'm not relaxing up in the legal. The court lacks jurisdiction over the subject matter. Y'all don't have no right.
Get this off of you, girl. Maybe if you weren't acting like a 4-year-old who just got told no more Mickey Mouse, you wouldn't be strapped into that chair like a full-blown disruption. And when I say disruption, I'm being generous, because at this point, she's basically the poster child for chaos. Seriously, if someone ever did a psychological deep dive on sovereign citizens, she'd be the cover photo. And here's the wildest part. She's got 7 officers tied up dealing with her. 7. That's like half the department babysitting this one-person meltdown while real crimes are happening across town. Someone's probably getting their car stolen right now, but nope. It's all hands on deck for Queen Delusion. Honestly, they should send her a bill for wasting that much time and manpower. It probably cost more than the fake diplomatic immunity card she bought off some sketchy Facebook group. You can just see it on the officers' faces. They're so over it. But credit where it's due, they're handling it with way more patience than most people would. I'd be asking for hazard pay just for sitting through this circus.
If I could have just a second, Your Honor.
I ain't never been biting with y'all.
What's the statutory reference to the 2-year enhancement? I can't remember that.
It is, I'm sorry, Your Honor, it is 708D. And I don't know that I made that entirely clear, but it just, whatever the sentence, the court prescribes, each sentence gets a 2-year enhancement.
Is that ARS 13-708?
Yes, I'm sorry, ARS 13708.
But not as to the misdemeanor, obviously.
Not as to the misdemeanor. I concur with the misdemeanor assessment that probation had, that it's just time served in the county jail, that she's already fulfilled more than the requirement for that. I agree that the presumptive terms are warranted in the other cases as well, Your Honor. I would point out that the jury during the aggravation phase, the jury found 4 aggravators. They found 4 aggravators. We have no mitigators here that I can see. Even with all of that, I would still ask for the presumptive terms as a Category 2 repetitive offender with the enhancements for the 13708D. I think that these charges probably would be warranted to run concurrent with each other, but I do feel that they should run consecutive to the defendant's prior case. She caused more harm and more emotional stress to the victim, the owner of the property, and then we have separate victims as to the resisting arrest charge and the fleeing from law enforcement charge, Your Honor. I don't have anything more to add than that, and there's no victims present. There's some representatives, some neighbors, some people from the Morningstar Ranch that are still living in the area. They're present here today just to watch, I suppose.
Very well. Thank you very much. All right, the court imposes a sentence as follows. As to count 1, unlawful flight, a Class 5 felony, the court, as I said, finds the offense to be non-repetitive, non-dangerous. The court imposes the presumptive term of 1.5 years in the Arizona Department of Corrections. The court imposes an additional 2 years sentencing enhancement because this offense was committed while the defendant was on pretrial release, and that's pursuant to ARS 13708D. So the total sentence as to count 1, Class 5 felony, is 3.5 years. As to count 2, this is the misdemeanor criminal damage. The court imposes a sentence of time served. As to count 4, again, the court finds this to be non-dangerous and non-repetitive. This is burglary in the 2nd degree, Class 3 felony. The court imposes the presumptive term of 3.5 years. The court also imposes the sentencing enhancement pursuant to 13708D of 2 years. So the total offense level, the total sentence for count 4 is 5.5 years. As to count 5, resisting arrest, it's a Class 6 felony, non-dangerous, non-repetitive. The court imposes the presumptive sentence of 1 year. The court further imposes the sentencing enhancement as required by law under ARS 13708D for 2 years, for a total of 3 years. As to
You know what's crazy? The whole sovereign citizen thing isn't even shocking anymore. It feels like every single day there's a new video of someone yelling about maritime law and free inhabitant nonsense right before they get cuffed and hauled off. And honestly, a lot of this chaos seems to come from a bigger breakdown, politics spiraling out, families falling apart, and people finding identity in conspiracy theories instead of reality. Let me know if you agree, but I swear half of these folks probably spent more time watching YouTube rabbit holes than having a stable influence to teach them basic life skills, like, I don't know, following the law? Now they're out here trying to declare independence from reality like it's going to shield them from consequences. Spoiler, it doesn't. Sovereign citizen logic holds about as much weight in court as a Monopoly get-out-of-jail-free card. Actually, the Monopoly card might have a better shot. Judges have consistently ruled that all their arguments, diplomatic immunity, strawman theories, rejecting citizenship, are legally meaningless. It's like legal Jenga. They keep pulling out random blocks of nonsense until the whole thing collapses on top of them. But yeah, I want to know what you think. This one was wild. I haven't seen someone act like that in court in a long time. Drop your thoughts in the comments. I always love reading what you guys have to say. Take care, and I'll see you in the next one.